I want to thank David Gates for doing this with us today. Also, he's got a family with a very current lived experience around this area joining us. So I want to thank the Buckwalters. I think by the number of people that are with us today, that you're probably mostly familiar with David Gates. He's presented and worked with individuals with developmental disabilities and us families and support groups in federal and state courts, administrative agencies, and the PA legislature for decades. I'm going to turn it over to David because we want to get going, and we can get as much of this in as we can. So, David, do you want to take it from here?
Sure, sure. Can people hear me?
Yep, I can hear you.
Oh, good, good. All right. Well, thank you, Francine. I want to thank Vision for Equality for sponsoring this, I think, very important, although challenging, topic. And that is, what do you do when your AE or county says we're going to reduce your hours, or you're not going to get a service that you've requested, or you're applying for a waiver and they say you don't meet the eligibility criteria. And the most common reaction is to try to talk to the county, try to negotiate. But there is a formal appeal process which is available to folks who are either applying for waiver or have got a waiver slot and are having their services denied or terminated. So we're going to talk about that appeal process today. And as Francine mentioned, I'm joined by Robin and Brett Buckwalter and their son Colin, who are going through this very appeal process now, and they're going to provide some hands-on advice as to what they've been through and what they've done to present the best a case they can in their appeal. Okay, so first of all, why appeal? Well, if you have a current service and the AE is either terminating one of those services or reducing the hours of those services, or denying something we call a variance, which is that exception where if you need more than 14 hours a day of support, or if you're looking for 2-to-1 services, or if you're looking for enhanced services, those are all done through variances. If that is denied, you have the right to have an appeal. If you're already getting the service, and this is important, if you're already getting the service, the only way to ensure that you can continue to receive that service while you're trying to resolve this matter is by filing a timely appeal. You can keep talking to the county, the AE. They may say, well, send us something and we'll figure it out. But understand, if at the end of the day, they're not happy with what you've sent, or they don't buy what you've sent, your services are going to be cut. And so filing the appeal is really the only way to ensure that you can continue to receive those services while you're trying to work things out with the county or AE. And ultimately, if you can't work things out, you can have your dispute heard by an independent third party. Number two, you should appeal because by appealing, you get certain rights, which I'll talk about in a little bit, certain rights to obtain documents from the AE regarding services that are at issue. Number three, it gives you the right to have a meeting with your AE. This is called, under the regulations, it's mandatory for the AE to allow you to have this. You don't have to do it, but AE, if you ask, must give you this opportunity for what's called a pre-hearing conference, which is an opportunity for you to clarify the reasons for the AE's decision and make your case to the AE or county as to why they were wrong, to present additional documentation to prove your case. And then last reason is sometimes you win. Now, I'm now going to give you some advice that I just got today. It was forwarded to me by Francine from DCOCHIA. I'm just going to read some things she said because I think it's important. And these are her words. I encourage families, the minute they get the notice reducing hours, to sign for a hearing as a protection for things to stay in place. Many do not for fear it will bring on the hearing. Second, oh, sorry. We'll talk about dispelling those fears about the hearing. Second, request the administrative review with their AE. That is that pre-hearing conference I just mentioned. Do everything to delay this loss of service. Number two, if this is happening because they say you are not using the services, i.e. underutilization of services, it is important to keep a running notation every time your loved one doesn't get the service. Why, for example, no staff, staff never showed, staff came late, left early, weather, illness, whatever kept the service unused. They will need to justify why the service didn't happen. Mention to them that now underutilization is going to be used to cut back or remove services. Some of you may have read news accounts or seen something on TV about significant budget cuts that are being proposed in Congress that would affect Medicaid. Waivers are a part of Medicaid. So if Medicaid is cut, that can result in reduced federal funding for Medicaid and for waivers. Now, here, this is my personal opinion. I fear that one of the things the state may be forced into doing if they lose billions of federal dollars is to start ratcheting down on services. So this is why I think Dee's advice is so important. I think it will get even more important if and when the federal government cuts Medicaid funding. Okay. Now, next thing is the appeals. Actually, there are several laws governing the appeals. They are found in state regulation, 55 PA Code, Section 275 and Section 105.5. And by the way, uh, I have done an outline. This is really kind of too complex for PowerPoints. I think PowerPoints are good for kind of simple, basic stuff. This, however, is detailed stuff. There's no way to get around that. So I've done an outline. I'm sending that when we finished here to Francine, and Vision can make that available to those of you who are enrolled for this session. So don't feel you've got to take a lot of notes. It will be in the outline. Okay, so there's a developmental programs bulletin that sets out appeal rights. That's important. In fact, let me do a share my screen here. There we go, share. Okay, share. On which screen do I get to share? Let me share that. I want to share this. And okay, let's get the bulletin. There it is. So this is the bulletin. It's an old one, but this sets out requirements. They call it due process and fair hearing procedures. And we can send that out along with the outline as well. Gives you some details about the appeal process. But it's not the only thing that governs appeals. As I said, there are two state regulations. There's something called a supplemental handbook, and there's actually the waivers themselves. The waivers, these are the documents that the state sends to the federal government, which has the legally binding criteria for operating the waivers. In there there is something called Appendix F as in Frank that sets out appeal rights as well. Okay, so what all is appealable? I think actually it is in here, but I'm going to all right, let me just go through this. If you're determined, well, let me say there is sort of two areas where you might face an appeal, and they go in different paths. One is if you're determined, and this would typically be a new applicant, to be financially ineligible for the waiver, or on recertification deemed no longer financially eligible. We don't see this a lot in the ODP waivers, but it does come up from time to time because there are income limits for the waivers. Now, for for youth under 21, the parental income doesn't count, but certainly at 21, the individual's income counts. So there are situations where that happens. That is appealable, but that is done through a different process, not an appeal to the AE, but rather to the folks who do the income verification and income eligibility criteria. Those are known as the county assistance offices. That's confusing because you think, well, a county office. County assistance offices are not, despite their name, county offices. They are state offices. They're the ones that do financial eligibility, not the service reviews. They're not part of ODP. If you get a notice from them saying you're financially ineligible, the appeal goes to the county assistance office. Don't bother talking to your AE. It's not something they deal with. Okay. Now, if you're determined to be clinically ineligible because you don't meet the intellectual disability, autism, or medically complex condition standards, that is something which is determined by a reviewer from the AE. There is a notice that comes from the AE. And by the way, I'm using the term AE here, which means administrative entity, just so you understand, when we're talking about waivers, the correct legal term is administrative entity, not county. If we're talking about base funded services, then it's the county. We kind of use them synonymously because in many cases, the AE is the county agency. But just so you understand, when I'm talking about waiver, I will use the term AE, administrative entity. Okay, so if it's determination you don't meet the clinical criteria, that's done by a reviewer from the AE. You get a notice, appeal is made to the AE. Now, in the case, and this would be the most likely case, where you are on the waiver, but the services that are requested either are not being approved, or the services that were approved, the AE is now saying, no, you don't need that many hours. You're not, as we mentioned before, you're not utilizing all those hours. So we are reducing those hours. A written notice is required to be sent by the AE to you, not just call the supports coordinator. I mean, that happens too, but it has to be a written notice. Okay. Now, what is not appealable? You do not have an appeal right if you've gone through the eligibility process, you've been found eligible, but now are put on the waiting list. In other words, you're not getting a slot, you're on the waiting list. You cannot appeal the decision that you're going on the waiting list rather than getting a slot. You can talk to your AE, you can work with your supports coordinator, but you can't go through the formal Department of Human Services appeal process. Uh, in terms of the supports intensity scale assessment, the so-called SIS, you can, and that which also drives the needs category. You cannot go through the Department of Human Services fair hearing appeal process to contest that, but you can review a request. You can request a review, by the way, to be submitted if you believe that a mistake was made in the SIS or the needs category. That is found in the ODP announcement 23-028. All right. Now, here's something I want to alert people to. You're having, you're saying, well, my son or daughter needs more hours, or the hours, maybe they need 2-to-1. And you talk to your supports coordinator about doing that. And there's a process you can do. You can reopen the ISP. There's actually a form to use. We'll just talk about in a minute, though, that form. Right now, I want to mention that I have heard of situations where a supports coordinator will say, well, I understand what you're asking for, but there's no way the county's going to approve that. So if, in fact, you don't press and insist that the supports coordinator actually make the request for that service, so the request is never formally submitted to the AE, that way the AE does not actually make a decision, you have no appeal right, because there's no actual denial by the AE for you to appeal. So if it's something you feel strongly about, regardless of what the supports coordinator feels that, oh, no, they won't approve it, if you really want it, you need to insist, I want to have that submitted to the AE for review. And sure, they may well send me a denial notice. I am going to appeal that. And the only way I get to appeal is by you sending that in, making that request. Okay. Now, how do you appeal? So if this is a decision by the county assistance office, at the financial folks, they will send a written notice, and the written notice is really quite thorough in explaining to you how you appeal. So you just read that, follow the steps. You can start an appeal with the county assistance office by calling the county assistance office. I will tell you from my experience, good luck. It is almost impossible to get somebody to answer a phone at the county assistance office. My own personal experience, I can tell you that the only way I got calls back from the county assistance office is when I filed appeals, and they call you back. Otherwise, they're not likely to. So file your appeal in writing. Okay, for decisions that are made by your administrative entity, your AE, or if it's a decision by ODP, you can call the administrative entity, and they are required, if you can get through to somebody, to actually take note of the date on which you ask for an appeal. You do need to be very clear, if you're going to orally request an appeal, that you use the magic language, I want to appeal. You can't just say, I don't like this, this is a bad decision, it's wrong. That kind of ends up in being endless discussions with the AE, and they'll just talk you to death. You want to make sure you say the language, magic language, I want to appeal. Now, after that, there is a form. I tell you, ODP has forms for just about everything. And the form here is the DP 458 form, which should be showing on your screen now. And this is the form that you would fill out and submit to the AE. One here. Now, let's go through this form a bit because this is actually important. Now, I want to mention this part here. I request this appeal based on the following actions. All right, so you do need to be very specific. What exactly is it that you are appealing? The next part is I request the following remedies to resolve the appeal. So exactly what is it you want? If it's a question of just number of hours, one of the things that has come up in cases I've had is where there may be a dispute between overnight hours, weekend hours, hours that they're saying are just going to be companion versus in-home and community, hours that are 2-to-1 versus 1-to-1. And so there may be a couple of different matters involved here. So you want to make sure in the first part which actions you're appealing. Is it everything? We'll spell it out. And then what is it that you want resolved? Is it that, and go through each one. If it's more than one set of hours that are involved, specify them. Okay. The next thing is we go down to the checkbox. And the checkbox here you see it says, I want a telephone hearing. I want a telephone hearing, and my witnesses will be at one of the following. I want a face-to-face hearing. Now, I have not had a telephone hearing where somebody has done this at the AE. Honestly, I have no experience with that. I have done both telephone hearings where people do that from their home, and I've done face-to-face hearings. So this is an important decision. Which should you choose? Well, let's talk about the face-to-face hearing. There are pros and cons. The pro is that it enables the hearing officer to see the individual if that is relevant to the issue on appeal. Number two, it allows you to show documents and photos to your witnesses. We'll talk about witnesses in a little bit. Number three, it allows you to show tangible items like assistive technology, AAC, or mobility equipment if that is relevant to the appeal. You can actually, have that right there in the room. Number four, some people feel more comfortable talking directly to the hearing officer in person than over the phone. Now, there are some cons to this. One is that in-person hearings are held in a couple of different offices around the state, but not in every county. So there may well not be an office in your county. You may have to travel some distance, depending on where you live, to get to the hearing office. Number two, this may be more stressful to the individual to be in an unfamiliar setting. It may be necessary to be sure that the individual has support staff if they're going to be there at the hearing. Now, at this point, I want to ask the Buckwalders to share with you their experience in this part. They're going to be sharing all through this presentation. But in this part here, why they made the decision that they made and what they had to do to ensure that they were able to get the particular type of hearing they requested.
Thank you, David. Robin Buckwalter, Collins here, and Brett. So there's three of us on this time. We wanted to request the hearing in person, even though it was difficult. It was in Harrisburg, so we had to drive about an hour after a holiday weekend in order to be there at 9 a.m. to meet with the judge. But we felt it was very important that the judge see the level of detail that Collins takes and how hard his SSPs worked for enhanced services. Colin is an augmentative communication device user. He uses a Frankie-Romich accent. So just that alone shows the complexity of Colin's needs. We have 2-to-1 staffing. So showing exactly what those staff did, what the SSPs, the high level of skill that it takes to get the device up and running properly for Colin to be able to communicate properly. Colin also has a couple of medical diagnoses that have to be managed in order for him to use the communication device. And he also has some behavioral issues that need to be managed by his SSPs in order to be able to communicate effectively. So we really felt in the end that it was critical that the judge see Colin face to face. And it's also very important for Colin to be a part of being an advocate for himself, for speaking up for himself. And he had prepared a speech specifically for the judge talking about his needs. Something else missing?
Wait, how you went about getting the space?
Colin's going to address that.
Okay.
Yeah.
Okay, so yes, so is Colin, if Colin wants to say something, anything now, or he can say something later at any time. I will just say this may be a fairly lengthy presentation because there's a lot here. So I don't want Colin to be uncomfortable waiting, for
I
a
appreciate
long
that.
time. So
We
if he
prepared
wants
for
to go
that.
now,
No, we're okay.
if
We're okay.
We're
you're
okay.
okay,
Yeah.
all
We
right,
can take a
so
break
then-
later, but for right now, we're good. Right?
all right,
Okay. All right.
all right. Good to see you, Colin.
Yeah.
Okay. Now, next point. What if the AE asks you to discuss the matter and not file an appeal? Let's just talk about it. Let's see if we can work this out. Well, here's the issue. If it is a service that you've been receiving, you have a very limited timeline to file your appeal in order to continue that services by virtue of the appeal. The timeline in ODP document says 10 days from the date of the notice. There is another document, more recent one, that's kind of generic to all Department of Human Service appeals that says 15 days. Either way, it's a short time. But what you need to be aware of, that clock is ticking. The longer you talk, if you go past that 10 or 15-day time limit and you're still talking, your services are going to be stopped or reduced. No matter, you could be in the middle, it doesn't matter. There is no legal right to continue services after that 10 or 15-day time limit, even though you're still discussing it with the AE. So again, I don't want to reiterate Dee's advice, file the appeal, file first, talk later. Okay. Now, what if the AE says, oh, no. Once you file the appeal, we're not allowed to talk to you? Baloney. That's not what the law says. The law is quite clear that they have to give you a pre-hearing conference. So they will still have to talk to you, even if they say they can't. Yes, they can. Now, that doesn't mean they have to return all your phone calls, but they do have to give you the opportunity and participate in a pre-hearing conference. Okay. What else? Yes. Now, in terms of this 10 or 15-day, like I said, ODP says 10, the state DHS says 15. What's important here is that you have evidence of when you filed the appeal. If you start by doing it verbally, you need to make sure that you get the name of the person you talk to. When you say, I want to appeal, say the magic language. What's their name? Put down the date. But then follow it up with this DP form here, the 458, DP 458 form that we went through. They have to give you that. You should be able to get it from your supports coordinator, but the AE is certainly required to give you that form. Sometimes they will send it with the notice, get that written and send that in. right away. When you send it, I strongly advise that you mail it certified mail with when you do something certified, you can get the return receipt, the green card, that's fine. But what actually, the date that actually counts, when you go into the post office, there's a form you fill out. In addition to the green card, it's a white card with green lettering, and that's where you fill in who it's to. And then the post office date stamps it with a red date stamp. That's the date in which legally your appeal is deemed to be filed. Keep that. When I do these, I scan them in on my scanner and put them into my computer so I know that's your proof. So if something happens, the AE says, oh, we didn't get it, or we didn't receive it until after the 10 or 15 days, you've got the proof of when it was mailed at the post office, and that triggers the time limits on the appeal. Okay. If this is not an appeal from a service you're already receiving, you have 30 days from the date of the notice to appeal. Now, filing the appeal in that situation does not get you those services. You've never had them. You're not going to get them unless and until either the AE changes their mind or you go through the fair hearing and you get your appeal sustained by the hearing officer. In a case where they fail to give you a written notice, you then have 6 months to appeal. By the way, if you miss that 15-day timeline for ongoing, you can still appeal. You have full 30 days. However, you don't have a legal right to get those services back pending the appeal decision. Now, what happens after the AE gets your appeal? At this point, I'm going to turn back to the Buckwalters to tell you their experience. There is something there are a set of instructions about what the AEs are supposed to do, but I think it's more interesting to hear what in fact they did.
Do you want to talk about the?
I do.
Okay.
Thank you, David.
Yes.
So in our case, we filed the hearing notice and we sent it into the region. We're in the Lancaster region, so we sent it to the Lancaster AE. The state is currently moving from doing these through the mail or through email. They're doing an electronic form. And it is my understanding that our appeal was the first one in Lancaster that was filed electronically with the state or with the state. In this case, we sent in a written form. The AE was supposed to upload it for the request and approve some documentation for that hearing. For some reason, the documentation was never attached. So when the state received the request for the fair hearing, the documentation was missing. So we were when we got back, I got a notice that there was a request for more information from the judge, and I had to go call the judge's office to speak to them about what was missing. So you have to make sure that when you submit your hearing form, that the AE uploads all the appropriate documentation. You have no way of checking on them. That was the big thing we learned. They have to do it. If they miss something, you have no way of knowing it until you get the request for the hearing.
Okay, and Brett, no, you said you got notice from the judge.
We got notice
Wait.
we got notice from the hearing officer that there was missing documentation.
Right, and
The
that
rule
was
to show
what was it?
a rule. to
Okay,
show
so
cause.
right, so that's okay. That's important. So this is something, and this is actually a formal legal order called Rule to Show Cause, which means that they will not process your appeal unless you explain or provide them with some additional information. And Brett, that's exactly what you did. But this is something that you can't ignore. Should you get one of these called Rule to Show Cause, you've got to respond to the Bureau of Hearings and Appeals.
Right, and the clock is running the entire time you do that. And I have to say, I called the court, left a message, and was called back within the hour about what was going on with the rule of show cause. and they told me what was going on. What I learned from that was because the AE didn't do the proper documentation, it became our job, it became our responsibility to show the cause, which was the appeal, which was the denial of the variance, not only to the court, but back to the AE and back to ODP. So because the AE did not upload the proper documentation, it then became our problem to make sure that all the proper documentation was resolved. I also learned through that there are two ways of doing it. You can either fax it or certify mail it. They prefer one or the other, but not both. And I've decided to fax it, so I had proof that it had gone out with an index page showing reception of it, so that I had done it timely.
And they don't take emails.
They do not take emails.
Right. Okay.
I
So
think
now
that's
next,
one of the overall critical things to know is that you're figuring this out while you're in it. You are literally waiting for information to be forwarded to you so you can immediately respond to it because the clock is ticking. So you can't not look at your emails. You cannot not check your mail. You have to look at it. You have to figure out what it means quickly and then get back to them immediately about what's being done. And then you have to keep copies of everything showing that you've done what they've asked you to do. So I can't say that enough. You are responding immediately to a need and then having to document that you did respond to it.
okay, thanks. All right, moving on. I said that one of the reasons to appeal is that the county or AE must must give you the opportunity to talk to them, to provide information to them, and discuss the case. This is found in the regulations, and this is the pre-hearing conference. I'm going to read the couple sentences because this is something that the AEs must abide by. The county assistance office or administering agency, AEs are considered administering agencies. Shall means they have to. Shall offer the appellant. The appellant, if you have filed an appeal, you are called the appellant. Shall offer the appellant the opportunity for an agency conference to resolve, if possible, the appeal. The pre-hearing conference, now that's the regulation. Then the ODP bulletin goes on to talk about the pre-hearing conference. See if I can find that. Let's see. Anyway, let me just talk to you about that. The pre-hearing conference, according to the ODP bulletin, is that it gives both parties the opportunity to discuss and attempt to resolve the matter prior to the hearing. Next, it is an important opportunity to nail down with the AE or ODP, what are the reasons for denying or terminating the service in question, both to determine if there is any information you can provide which would resolve the denial or termination. And it also helps you to better be prepared for your hearing, because you'll hopefully will have a better idea what the hearing is about in case the appeal cannot be resolved. So let me just stop here. And now I want to ask the Buckwalders again to share their information, their experience with what would happen with them.
Okay.
Stop sharing.
Okay, this is probably the most critical thing that we learned is you absolutely have to understand what it is that's being denied. If you have to ask 20 times, ask 20 times. We thought we understood what was being denied, so we prepared just a little bit of background. It was a variance. part of the variance was being denied, and there were 3 parts to it that were being denied. And the interpretation was absolutely unclear as to what was being denied. We thought we understood it, but in reality, we did not. And, you know, we had been working on this for a while. We knew our stuff, but we totally missed that one. So that's the number one thing I would say at the pre-hearing conference, is to absolutely be clear in writing exactly what is being denied. And number 2, how it is specifically affecting the services that you're potentially going to be losing. Because we prepared our case with massive amounts of documentation, not realizing that one of the things was not really being denied. So, and to be clear, it was also confusing language that we think other people did not understand either. The judge that in the actual hearing, she spent a good portion of the time trying to understand exactly what was being denied herself. So it wasn't just us. So that's the number one thing I would say at the very beginning, even if you're not certain in the beginning, you're heading towards an appeal, but you're not certain, get that information immediately, because you've got to start working on your evidence. And if to work on your evidence, you need to understand exactly what you're preparing for. So for instance, if you're having specialists and doctors and all sorts of different information, you have to put in there specifically, not that there's a general problem, but specifically what's being denied and why that would result in harm to the person that you are filing the appeal for. Do you want to add anything? No, okay.
Excellent, thank you. All right, so now we're going to move on to the preparation for the hearing, and Robin has already given you an idea of some of what's involved in preparing, and it is a lot of work. One of the first things I want to mention is if you choose a face-to-face or in-person hearing, you want to confirm the accessibility of the hearing office and hearing room. Having done this, I can tell you that not all of the rooms in which hearings are held are fully accessible. The offices that I've done hearings in 3 different state offices. They do have elevators. The one in Harrisburg is pretty tight, but I guess they would be deemed accessible, but the rooms some of them are just really too small if you have a number of people. So being able to confirm that the hearing room will actually meet your needs is important. And I'm going to go back to the Buckwalders for them to explain their experience with that.
Okay, Colin's using his augmentative communication device. So he has prepared a statement. So hopefully everyone can hear this.
It's very important, if you need an accessible courtroom, to ask in writing for accommodation as soon as possible, and to follow up with phone calls and emails to make sure they have your request. The room they originally gave us was tiny and my power chair would not fit. Then security guard clarified I had made request for accommodation, and we got large courtroom and we could all fit inside. Be polite, but make sure to follow up. And keep copies of anything written and bring all copies with you.
Thank you, Colin.
If I
Good
just
advice.
add to Colin, just want to add to that. We got there early to make sure that we had space. So give yourself some time, because if we hadn't seen the first room, we would not have all fit, and Colin would not have fit in the first room that they showed us. So get there early so you can make sure that we have the space.
Correct. We had actually called when we got the judge's letter detailing very specifically what the rules were so that we could abide by them correctly. One of the things that was not mentioned was when the courtroom actually opened. So we called and we found out specifically when we could be there, which was a good thing because we were there when they opened, but we didn't know which entrance to go in. And the elevator was teeny tiny, so we had to negotiate that. So allow yourself time to get lost, allow yourself time to figure things out, allow yourself time to make sure that you bring all your documentation with you. We had bags and bags and bags of notebooks, boxes, evidence that we were bringing with us, so it took us a while. You also have to be screened to go in, obviously, and sign in. So there's a lot of procedures. But one of the things that we did do when we got the judge's letter was to make sure we understood the rules, and we called and we asked about the rules specifically. Don't be afraid to ask, but like Colin says, be polite, be nice, but get the information so you can plan in advance, because it is confusing. The other thing that I would mention, and it's sometimes just the devil is in the details. Something as small as the original letter that we got from the judge was sent via email. I almost went to my junk mail. I opened it up and then we realized what it was. That gave us an extra 6 days to ask questions and prepare before the the actual letter arrived from the Postal Service 6 days later. So if we hadn't have seen that in the email, we would have lost 6 days. And I'll be honest, it was a mad scramble to try to get everything documented and proper, which we can talk about that a little bit later. But it was very difficult because we had never done this before. So give yourself as much time to ask as many questions as possible.
Okay. All right. So next thing in preparing for the hearing is the right to get documents. So there is a requirement, and now I will share again. Hold on. Here. So this is the regulations. Let me increase those so you can see them. So you are, here it is. This one here, you have the right to examine prior to the hearing, as well as during the hearing, documents which the AE, the administrative agency, will introduce as evidence, as well as contents of the case file. Now, there's another regulation, which is over here, that talks about right to see the case file. So you have that right to get those documents. So that's another reason to file an appeal. They actually have to give you certain documents. Anything that they're going to show at the hearing, they must give you in advance. I can tell you that we have been successful in getting hearing officers to disregard documents that were submitted at the hearing by the county or the AE if they were not provided to us in advance. But you got to make the request. You must make the request. It's not automatic. Okay, so you can get anything they're going to present. You also get to know, next page here, the names of who is going to attend on behalf of the AE, who's going to be a witness. And this also gives you the right to know some counties do, in fact, have attorneys, usually their county solicitor, who will actually represent them in the hearing. Most of the time they do not, but they may. You have the right to find that out in advance. Again, you need to request it. The regulation is quite clear. All right, next thing is, what is the issue? Now we're talking about preparing here. So Robin spoke about not having clear understanding from the written notice what the issue was. And one of the reasons to go through the pre-hearing conference was to really clarify what the issue is. So that is really important that you, when you prepare your case, know exactly what the issue is. You're going to prepare regarding that issue. Next, what do you need to present at the hearing? So what are the relevant laws? By laws, I mean regulations, provisions in the waiver, and bulletins, or ODP announcements that are policy statements that apply to the issue that you have defined. Then, based on the requirements found in the applicable regulation, waiver provisions, bulletins, what information do you need to present at the hearing to show that you meet those requirements that are specified in the waiver, the bulletins, regulation? Now, the next step is, having figured out what information you need to present, next step is, where are you going to get that information? Is it going to be from documents? It may be the ISP. It may certainly be some assessments. Is there a behavioral assessment? Is there a communication assessment? What kind of assessments may be available? A physical therapy assessment? Do these assessments include information that is relevant to what you need to prove? Gather those together. You may even wish to highlight some of those so it's clear. Often, if I'm working with a large number of documents, I will actually make one copy for the hearing officer, one copy for the AE, and then the copy I keep for myself, I will get those little tabs. You can get them at Staples, so that when I compile all my documents together, I can put the tabs with little labels as to what that particular page shows, what it is I'm going to refer to that page for. Okay, so documents. You have the ISP, you have the SIS. I talked about evals, talked about letters from medical or behavioral practitioners. It is very important, particularly for these letters, that they be submitted to the AE before the hearing. If you walk in with a letter you just got and the AE hasn't had it, they will probably make a stink. And in fact, hearing officers have excluded letters from practitioners that were not given to the AE in advance. Also, there'll be service notes, which was certainly the big issue for the Buckwalders, progress notes, correspondence with or from AE or provider. You need to mark each document. Document should be entitled the capital letter A dash and then numerically sequentially, because that's how they do it. A is for appellant, and then there would usually be a C for the county. And you will mark all of those. And there's a reason for doing that when you get to the hearing. So now, if the Buckwalders want to talk about how they compiled their documents, because as Robin said, they had a lot. So if we can talk about that.
Well, let me suffice to say that there's no such thing as too much. We had 12 folders filled with documents that we had been collecting for a very, very long time. But it was really, really important that we did that. So let me start with it. First off, one thing that we didn't talk about was the judges at these hearings are not experts on ODP. They might have some previous experience, they might not. So you cannot assume that they know what an AE is or an SSP is or what an enhanced service is. You have to explain it to them so that they can understand it. So that was critical. And that's one of the reasons we probably went overboard on our evidence, was to make sure that we had too much information that they could pick and choose through if they wanted to. So that's the most critical thing. David, do you have any comments on that? Okay, all
That's
right.
fine.
The second thing we had, I thought it was absolutely critical, was a supports broker. We have Terrapin House as our supports brokers, and they did an absolutely amazing job in making sure that we understood the bulletins and the communications. And we actually had a document for the judge that was all the pertinent bulletins that were labeled, highlighted, and checked, so that we could say, because it was a very, very fine point that we were being denied, Colin was being denied the services. So we thought it was critical for the judge to have the actual documentation. And then there was a table of contents so you could rapidly click through. And yes, David, we like the Post-its with the stars and the numbers too. And then we highlighted everything and we put the pointed things on it in terms of what it was regarding. We felt that we wanted to make it as easy as possible for the judge to look at our evidence. We even gave her a red folder that was the most critical evidence. So if she only had a certain amount of time, which that turned out to be the case, then she could review the red folder with the most critical documentation. The other thing that I would say is this all happened so quickly and you have to learn so much. It really is a challenge. It really is. So if you think that you might be going to appeal, start now. Do not wait. Get your letters from your pertinent people, your specialists, your doctors, behavioral therapists. If in doubt, get a letter specifically. It can't be, well, you just have this general thing that's going on. Specifically related to what service is being denied. And this is the most critical thing. And I think we got this from both David and the supports broker. It was, what will happen if those services are taken away? That is critical because they need to know it's not a nice to have. It's like, what is going to be detrimental for the person that you are submitting the appeal for? How is that going to hurt their life? How is it going to hurt their health? How is it going to hurt their behaviors? That's most critical. And I don't know how to say this politely, so I'm just going to go ahead and say it. What, as parents or guardians, what we say is not expert testimony. We are just people who want to do the best for our kids. So while it's nice to hear from the parents and the guardians, you have got to have expert testimony and expert documentation. And that's what we went for. Is the best way possible. Now, keep also in mind, like I said previously, there was confusion about what exactly was being denied. So again, we probably submitted way too much, but I'd much rather have way too much than way too little. At least we can say we fought the good fight. We did the best we can. And then the final thing, take a lesson from my book, organize it. We were so behind the 8 ball just trying to get all this evidence ready. There were some times when we had difficulty finding our evidence. So make sure that you have it all organized and at your fingertips. I color coded the death out of everything. And you have to do that in order to be able to have it. And if you are not an organized person, find someone a friend, a family member, someone to help you get this organized so that you have it, because you've got so much going on when you're in appeal. You need to have your best people on your team to help you get through this.
Yes,
I'm going
that's
to add something to it here. I'm
Sure.
going to work backwards. We spent a lot of time organizing our information so that we made sure that it was in the same order that we gave it to the AE and we gave it to the judge. According to the documentation, you have to make sure that the AE has it 5 days before the hearing. We were having a hearing our hearing was the day after Memorial Day. So that was one day that was excluded out. The other thing is that the judge doesn't want to have any of the documentation until the hearing. Robin, my wife, called them and asked them about viewing videos, because one of the things that we wanted to prove to the judges the need for 2-to-1 enhanced services for all of his durable medical equipment. So obviously you can't bring in 11 pieces of equipment into the courtroom and show them. So we wanted to show video of it being used. She contacted the court. The court said they had no way of viewing. I went to bring a flash drive and they would not do that. So they wanted me to make DVDs and send them ahead of time so that the judge could view it ahead of time. And she did. She said in the hearing that she had viewed all of the stuff that I sent them ahead of time. And I tried to keep them brief. I sent them a total of 15 videos, and the entire runtime of those 15 videos was just under 20 minutes. So I was trying to keep them down to telling a short story. But we were looking for a way of burning a DVD with the software to do it in a timely manner, because we couldn't bring it into the courthouse. We had to send it to the judge to rule on it before the hearing happened. So we had essentially about 24, 48 hours to figure out how to make the videos, edit the videos, and download 2 DVDs. The judge, whatever we gave to the judge, we gave to the AE. So we sent the judge DVDs. We made sure we had the same DVDs for the AE.
It's the judge's rule. They get to determine what they're admitting. And they would not be able to admit a flash drive. So hence why it had to be DVDs. And she had to rule in advance about whether it would be admissible as evidence. So that was a critical part of our strategy, was to show rather than just talk about why Colin needed these services. So that was a critical point of our evidence. And I got to be honest, we were sweating bullets on that one.
So we had to find a DVD player. We had to find the DVDs. We got it done in time, but know that those are the little obstacles that they don't tell you about.
Right.
There's no, unless you ask questions, call the judge, call the office of the hearing judge. They will answer them for you and get you back information. And once again, they were very good about always answering our questions in a timely manner.
They were excellent.
So,
But don't
Great,
be
but
afraid to ask the questions multiple times if you don't understand the answer.
Right.
Come back to it in a different way and ask, and be polite, be nice, say thank you and please. But be very nicely aggressive about getting the answers that you need.
I also wanted to say that for prepping for this, one of the reasons we're doing this today is because there weren't a lot of families we could find who had been through this. I did speak to DRP. Yeah, the DRP. They were very helpful. They gave me some information. I spoke to another lawyer who does disability rights. They were very helpful. And my local ARC, the advocate there gave me lots of good information. So I appreciate all of those people and the time they gave it to us. And Davis also gave us some help. So I did, I want to say I pulled the string. I think if I hadn't kept pulling the string and asking people questions, we wouldn't have been as prepared as we were.
Agreed.
Okay, so let me ask you guys a question. So the judge watched the DVD. That's great. Did the county? Did the AE?
No.
No. Okay. All right.
And we made sure that they had it ahead of time. They got it at the same time the judge did.
See, and that's another reason to file the appeal. I mean, you could say if you hadn't filed the appeal and you made this DVD and they never watched it, you wouldn't have got to anywhere. Here, at least you got the judge to watch it. So it was worth filing the appeal for that. I will point out, if you're going to do videos, there is a reason why you should also include some still photos in addition to the video, in that there is an appeal, or actually 2 kinds of appeals after the fair hearing, which are based on what's called the record. And the record is really the transcript and documents. So the record may or may not include a DVD because of the way they transmit the record. So you should also have some still photos in addition to the video. Also, talking about color coding, just a tip: if you're going to highlight, use a light yellow highlighter. Don't do anything dark, because when BHA, they make photocopies of the documents. You photocopy something with usually with a red highlighter, it kind of blacks out the text underneath. So use a light highlighter. All right, let's move on to witnesses. So in addition to documents, you have people who are going to provide direct information that is relevant to your case. Let me go back 1 second, if I may. In terms of letters from the doctors, therapists, those kind of expert letters, it's important that the letter contains, one, what is the person's credentials? Do they have, are they a physician? Are they a licensed physical therapist? Are they, what are their credentials? And then number two, what experience have they had with the individual? Have they done an assessment? Are they actually a treating provider? That should also be in the letter to substantiate the basis for their opinion. All right, back to witnesses. So we want to look for witnesses that either have direct knowledge of the individual's needs or challenges, or witnesses that have clinical expertise sufficient to offer an opinion as an expert witness based on information accessible at the hearing. Most cases, won't be expert witnesses, but you may have that. So you want to determine, are there folks who have that direct knowledge or have the expertise to be expert witnesses? Now, there is, let me share now. Okay. So you have the right here under 2 to request a subpoena from a hearing officer for the production of evidence or witnesses. So about subpoenas, let me say that subpoenas can be obtained from the Bureau of Hearings and Appeals, from the hearing officer. I have done it. We're going to hear from Buckwalters in a second about their experience, but under the regulation, you can get them. However, there is no enforcement mechanism, no way to enforce the subpoena. So it is really useless to get a subpoena for someone who is simply refusing to testify. Where a subpoena is useful is where you have, say, I'll give you an example, a behavior specialist who's working for an agency. And the agency says, no, we don't have our specialists testify at these fair hearings. Giving the agency the subpoena can often give them the cover they feel they need to allow that specialist to testify. Now, Buckwalters, you want to tell us about your experience with subpoenas?
We found subpoenas very confusing. As the clock was running out, we were trying to figure out all the rules of the court. And we did go to a provider who is paid for by the county. And that's exactly what they told us, per David. They said, we cannot testify unless there's a subpoena. So it's not in their interest to testify. So understandable, we get that. So I called the judge's office and that's saying, well, could you send a subpoena, not knowing how to do this? I'm not a lawyer. And they said, well, you have to hire a lawyer, and then the lawyer has to get the subpoena. And at that point in time, I think it was Friday on a 3-day weekend. So there was just no way we were going to ever get a subpoena. I think if it was really critical to your case, then you need to understand the rules way in advance to do that in time to make it happen. And quite simply, we ran out of time.
So, and that answer is wrong. The regulation just says you have the right, and by you, it's not just the attorney, it's the right of the appellant. Going back to that screen again. There we go. You can see here, rights of the appellant. It's your right to request a subpoena from the hearing officer. not the attorney's right, it's your right. So that answer was wrong. How it works is you make the request, then a blank form is usually sent by fax to you. It can be mailed. Mailing, unfortunately, usually takes too much time. So they do a fax. I've never had it done by email, but I have had them fax to me. It's a blank form. You have to fill it out. You have to serve it. Now, that's where you need to talk to the agency. Will they accept service by fax? Which case you just fill in the name of the agency and the person and you're done? Or do they insist on personal service, which means somebody's got to go over there, actually hand it to them? Uh, but that's how that works. But again, this is going to depend on the willingness of the provider agency to allow their staff to testify with the subpoena. Some of them won't even do it with a subpoena. So, all right, that's it. Now, the next thing is to discuss with, you have to prep your witness. I can tell you how many times I've done hearings and I've had somebody testify, and the next thing you know, out of their mouth comes something I never anticipated. It just sends the whole case spiraling in a different direction. It's important you prepare your witness. You want to discuss with them what they've seen, not, and if you're dealing with somebody like an SSP, for example, it's important for them to focus on their actual hands-on experience, what they've seen, what they've witnesses, with and not go into like opinions. Yes, it's important to have opinions. You rely on the people who have certifications, but you don't generally want to have opinions for SSPs because it's too easy for the AE. See, when you go to the hearing, the AE can ask questions of your witnesses, called cross-examination. It's too easy for them if your SSP goes off and says, well, yeah, but in my opinion, blah, blah, blah. And they can ask, well, what are your qualifications for which you have this opinion? And it just undermines all of their testimony. So if it's somebody who doesn't have specific credentials, is have them talk about what they've seen, what they've done, what they do, what they document, and don't offer opinions. You try to prep them to stay focused on the topic. You want to give them questions, and you can ask. Now, sometimes I will say the hearing officers will say you have a witness, and the hearing officer will just say, well, witness, just tell me about what it is you do for Colin. You can't really avoid that, but I do try to start out by saying, Your Honor, I would like to ask some questions of my witnesses. That way you kind of keep them focused and on track. You can't avoid it if the judge is going to ask some questions, but hopefully you start out keeping them on track. Okay. That's it for preparing for the hearing, unless you guys, Buckwalders, have anything else you want to talk about preparing before we get to the hearing.
No, I have something about the hearing, but not that. So.
Okay. All right. So now we'll go to the hearing itself. So hopefully you've done all this preparation. You figured out applicable regulations, bulletins, whatever. From there, and you've had your pre-hearing conference, and by all means do have the pre-hearing conference, even though you say it's just going to be a waste of time. Sometimes you can at least get some information out of the county that helps you focus your appeal, even if they're just going to repeat the same thing over again. So or at least you believe what the issues are. You figured out what the relevant regulations, bulletins are, and based on the issue and the regulations, you now decided what your evidence is. Evidence is documents and witnesses, and you've got that all lined up. And you've got your accessible hearing room. Now you go into the hearing, and this is what is supposed to happen, and in my experience, usually happens. The hearing officer will swear in the parties. They usually have a little tape recorder, and they ask people to identify themselves and their name and what is their relation to the appeal. And then they will usually ask the AE, what is the issue in question? What is the issue? And this is something where you need to be listening very carefully, because it may be that the AE will say, the issue is we did not get the documentation we requested. At this point, you can actually say to the judge, Your Honor, I disagree with the way that question, that issue was phrased. There is a provision in the regulations which states the question on appeal, therefore, is not whether the administering agency acted properly based on the information then available, but whether the appellant was eligible for the period of time at issue based upon evidence of eligibility the client is able to provide at or before the hearing. So if they say the issue is we didn't get the documentation, you say, I disagree. The issue is whether, in this case, Colin was eligible for those services at the time based upon the information we are going to present today. That is the issue. And I'm going to see where it is here. Benefits. Here it is. I'm going to show you a hearing decision where I successfully made that point. Let me get this here. Where's the no? There it is. There it is. Okay. Now let me show you how that works. There, and share. Okay. So this is an actual hearing decision, one of my clients, regarding the level of in-home community and community supports. The representative from the AE argued that based upon the information available at the time of the appellant's last ISP, a disservice decision was made. His ISP did not support increased service hours. Furthermore, new information provided after the completion of the ISP could not be considered. That was what the county, that was their position at the hearing. This is what the hearing officer wrote in his decision. The department's representative is incorrect in arguing that new information could not be considered. The regulations allow administering agencies like the AE to consider verification provided to the agency subsequent to its adverse action on the case. It shows that the appellant, in fact, met the substantive conditions of eligibility during the period of time at issue in the appeal. The question on appeal, therefore, is not whether the administrative agency acted properly based on the information then available, but whether the appellant was eligible for the period of time at issue based upon evidence of eligibility the client is able to provide at or before the hearing. The ALJ hearing officer just reiterated what the regulations say. So that, I think, is a really important point. Okay. Next. Previous service approvals. Let me stop this here. You may come into the situation, and certainly this was a situation for the Buckwaters, where the individual, Colin, had these services for many months, had been approved, done a new variance, been approved again. And I think that most people feel that the question, when we talk about what is the question at the hearing, should be whether anything has changed since the last approval that would result in a different decision, that would result in a denial. Unfortunately, hearing officers uniformly don't accept that as the issue. The hearing officers routinely contend that each service request or variance request is unique, so that unfortunately you are going to have to prove all over again that you meet the requirements for that particular service, and not just say, well, the condition hasn't changed. I can tell you that I have put that information into evidence to hopefully give the judge a little sympathy to the case, where where you can show that people are just being run around, that this was always done, it was always approved, and now suddenly the rules are all changed. So I put it in, but you still have to prove that the individual meets the criteria, not just based on past approvals. Now, and when I get through this, I'm going to ask the Buckwalters to give their whole input on the hearings, because they have, I think, a lot to say about that. But let me just finish this here. The next thing is, after the statement of the issue is decided, the judge agrees this is what the issue is. Next is the AE will present their case, and they can present documents, they can present witnesses. Now, you do have the right to make objections. You should definitely object to any effort by the AE to introduce or discuss documents they did not send to you before the hearing. Because the regulation that we went through, this 275.4, was real clear. It needs to be done before the hearing. So if they don't, you can object. You should object to any efforts by the AE to have witness testify that they did not tell you about before the hearing. Now, in both these situations, documents and witnesses, the objection only works if you did make the request. You've got to make the request to the AE before the hearing. A request pursuant to the 275.4 regulation that you submit all the documents you intend to enter into evidence, and the names of witnesses and titles of witnesses. You've got to do that. So when you make your objection, you should have a copy of the email or whatever some writing, which you can document that you made the request. Your Honor, I made the request. They didn't submit it. Therefore, I'm objecting to the submission of this document or having this witness testify. And I can tell you that there have been cases I've had, I know other people have had, where the AE or a county assistance office brought in some witnesses they didn't tell us about. We objected, and hearing officers have actually excluded witnesses from testifying if we were not told about it in advance where we requested that information. Another thing is that if the AE starts talking about what other third parties have said who are not present at the hearing, for example, they may say, well, the service provider says blah, 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 but it's not in the notes and the service provider isn't present, you can object. That is considered hearsay and it is objectionable. I will say you do need to be careful about making objections about third party, we call third party declarations, witnesses who are not in the room, because that same hearsay objection can be used against you for presenting letters from doctors and therapists. Technically speaking, if you bring in a letter from a doctor or a therapist that is not actually part of their medical records, that is hearsay and could be objected to. And if objected to, the ALJ could actually exclude it from evidence. So it's also useful when you want information come in from therapists, that if you have some records, their notes, therapy records, that is admissible despite a hearsay under the medical records exclusion. Okay. What else? Cross-exam. So now the AE they have put on their documents. And by the way, when the documents are submitted, the hearing officer will ask you, do you have any objections? Again, if you already had the documents, you should have looked at them and you will determine in advance whether you have objections, and you will say so. If you don't have any objections, just say no objections, Your Honor, and those will be admitted into evidence. But there's a process. In order for these records to be considered, they actually have to be admitted into evidence, which are submitted to the judge, and they are marked C1, C2, whatever for the AE, and then request is made. I move to admit the records into evidence, and then the judge, the hearing officer, will say on the record that I am admitting county exhibits, blah, blah, blah. All right. So those are admitted. Now you have the witnesses. The witnesses testify. I told you about what you can object to. You can also ask questions of anyone who testifies for the AE. I will say that do not try to make your case from the witnesses for the AE. Don't try to get them. I mean, this isn't like Perry Mason. You're not going to get them to admit, oh, yeah, Colin really does need that service level. That rarely works. So what you do want to do is focus on testimony from AE witnesses that are inconsistent either with their prior statements or evidence that you have where you can point to that something is different in the evidence. And you can do that through what we lawyers call leading questions, which is to say that, well, isn't it true that the ISP says this and you're saying that? Or isn't it true that the bulletin says this and you're saying something different? So that is permissible. However, it may be a better idea in this situation not to ask that question where there's an inconsistency as cross-examination, but save it to the end when you get your opportunity to make your what's called closing statement, and then point out, Your Honor, the AE said blah, 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 but here is the bulletin, which we've entered into evidence as Appellant's Exhibit A4, and the bulletin says something entirely different. The reason why you might want to do it in closing, not when the witness is saying that, is that there you run the risk of saying, well, isn't it true that, you just completely misread the bulletin? That they will come back and they'll try and spin this around to say, well, but really, that's not the way we interpret it, or ODP has said something different. So you may not want to cross-examine them. Cross-examining the AE is tricky business. And one thing you never do is to ask a question on cross-examination about a matter which you don't already know the answer to and can prove what the right answer is. Don't go there. They'll make stuff up, and it just can sink your case entirely. All right. So now AE is done. Your turn. You present the testimony of your witnesses. You then review each of the documents that you want to enter into evidence, that is for the hearing officer to consider. Hearing officer can only consider them if they are entered into evidence. You go through, Robin mentioned about doing this table of contents. I think that's great advice. Go through the table, You've marked them. Okay, Your Honor, A1 is the variance. A2 is the service note from such and such a time. A3 is the bulletin. And just go through it and kind of highlight for the hearing officer what it is you're talking about. So at that point, you have them all say, at this point, Your Honor, I move the admission of appellant's exhibits A1 through whatever. And that point, the hearing officer turns to the county. You have any objections? Maybe the county does, and then you'll have to fight that out. But if not, then and the ALJ will usually say, "Well, I will admit this, but take it under consideration." And then the hearing officer admits the documents. Okay. At that point, then the AE can now cross-examine your witness. You want to make sure your witnesses are aware that they may get questions asked. You may, in fact, I try to figure out what those questions may be, even though I'm not going to ask them. Sometimes I may actually ask questions that I think the AE will ask just to get the information out there and be able to ask follow-up questions, which may better explain what may look on its face as a bad answer. Your witnesses could be prepped to say, when listen to the question thoroughly, take your time before you answer. Make sure you understand the question after you've, I would say take 2 seconds before you open your mouth. Make sure you understand. If it's something you're not clear about, say, I'm sorry, I do not understand the question. You're allowed to say that. That is a perfectly admissible response. I do not understand the question. Don't have them go off on something what they think, and it's really something entirely different. You can object to questions that the AE is asking your witnesses. One thing is where it is something that your witness has already testified to. The stock objection is, Your Honor, asked and answered. Another one is where the AE starts asking a question that is completely outside the scope of what your witness testified about. So if you have a witness that's talking about, say, behavior issues, and AE's going to ask them about physical issues, you can object. And the objection there is, Your Honor, that is beyond the scope of direct. All right. Anyway, see what else here. However, the hearing officer can ask questions of anybody at any time. You really can't stop them from doing that. If you feel the hearing officer is going off on a tangent, you can try and say, Your Honor, I think we agreed at the beginning that the issue was X, and just kind of gently make that point. But you really can't object to questions asked by the hearing officer. And then when that is all done, the hearing officers have, in my experience, almost always given both parties an opportunity to make a closing statement. The AE will go first, and then you get a chance to respond. I usually do take notes, the AE's closing statements, although I usually write up an outline of my closing statement. I want to make sure that I am responding to what the AE says. So some of this is thinking on your feet. But if you really know your case, if you know what the issues are, if you know what the evidence is, you'll be able to respond. The AE says this. He says, well, Your Honor, if I could refer you to our appellate's exhibit A, whatever, and a testimony of the PT or the SSP that completely contradicts what the AE is saying. So you can do that in your closing. You don't interrupt during the closing, but you do that when they're done. The hearing officers do not like people getting into arguments with the AE during their closing. They don't like that. They'll let the AE go on, and then you have your opportunity. I should also point out the applicable regulation, waiver provision, or bulletin, which you are relying, and briefly summarize how your evidence, documents, and testimony show that the individual meets the requirements for the service in question. And now I'm going to turn it over to the Buckwalters for their experience regarding their hearing.
I'll start and Robin will weigh in. I'm going to go back to say something about providing the evidence. Our hearing was on Tuesday. We made sure that the AE had all of their documentation by the Wednesday beforehand. We had sent them all the documentation. We also sent them an email and a cover letter asking who was going to be there from the AE and if they were being represented by a lawyer. We never got a response to those two questions. But on Thursday night, late, we did receive their documentation via an email. It was very handy to look through it because it gave us an idea of what they were going to be asking questions about. So going into the hearing, our hearing was 3 hours. It was informal. As David said, the judge did ask lots of questions of both of us. Her very first question and the first 20 minutes of the hearing were her trying to get an answer from the AE about what the issue was. The variance was not well written, and she didn't know why we were there. And then she not only asked that for the first 20 minutes, she asked it again about halfway through, and then she asked it for the last time at the end of it. What is really the issue here? Well, the issue came down to the idea that we have a 6-month variance. So every 6 months, it's a new clock. It doesn't matter whether he's had this services for 2 years, 10 years, or 12 years, every 6 months. So the question was, what's reflected in our daily service notes for Colin for the services? And that's what this is going to come down to on her rulings. And she held up the ODP form for what how daily services notes are based on, and that's what she's going to rule on. As for witnesses, we did send the judge, we had 3 people who came to testify, and we had a 4th person who's an observer who was non-sworn in. So Robin, myself, Colin, 2 of our SSPs, and 3 of our SSPs were sworn in. So total of 6 of us sworn. There were 4 people from the AE that were there to give testimony. One of our SSPs has her master's in OT. Yeah, she's an OT, and she works for us part-time. We wanted her to talk about the videos. The judge said she didn't need to show the videos again, which kind of threw our witness off a little bit because she was really going to base her testimony on the videos as we were showing them. So she kind of had to she had to take a few minutes and gather her thoughts and talk about what it's like working for Colin, why Colin needs the services, why it's so difficult to work with him, why he needs professionals who are enhanced in their abilities. She also, because of her other role out there, she does a lot of intakes for an agency, and she spoke briefly about the ambiguity of ODP's regulations on the daily service notes. There were a lot of questions that went back and forth. David did mention about how you can ask for some evidence to be removed. When we got the information from BHDS, about a third of their packet was budget numbers. How much Collins services cost, how much we pay people, what the difference is. I made a motion right at the beginning for that to be excluded. The judge did not rule because I figured this was not about how much it costs, but what his services need to be. The judge did not rule at that time. She said she would take it under advisement. I have learned since then that they rarely throw something out that they take it under advisement, and they'll rule on it at a later date. The judge did give everybody a chance. She asked lots of questions. She asked questions of Robin and I. She asked questions of the AE. She asked questions of our SSPs. She was really trying to figure out what the question about why we were there. And we used every one of those 3 hours I mean, it went by in a blink of an eye. It's very informal. There was no lawyers there. That was very informal. And do you have anything to add, Robin?
Informal, define informal. Informal for a lawyer like David Gates and informal for a family like us. Totally different words. So yes, they can ask questions, but I thought it was going to be a little more loosey-goosey, but it wasn't. I mean, it was a serious
Serious
thing.
conversation.
I mean, evidence, making sure your evidence was real evidence and not opinion, understanding what the rules of the court were and were not, and responding to them at the last minute. I think informal threw me off quite a bit. And yeah, I think that was the hardest thing, being prepared for all of this and then being able to spin on a dime, like your only real witness isn't going to be presenting based on what you've submitted. So you have to be prepared to totally, respond. Brett making the request for the financial information not to be allowed. That was something we had to do spur of the moment. We had no idea. One thing that I thought was critical about the hearing goes back to what we keep saying over and over again. What are you there in court for? What is the judge going to be ruling on? And in the end, she was ruling on simply the variance, simply for 6 months, and simply on what the service notes were going to be. And she allowed evidence to be submitted after the fact.
Okay.
And she
Yes.
allowed us, we were allowed.
And then we had a
read-
chance to
we were-
review
She
it.
allowed the AE to submit evidence up to 5 days afterwards. They did submit it. They did send us a copy of it, and then she gave us an additional 5 days to respond to it, which we did.
We did. And that response, we were winging it because we didn't know what we could or could not respond to. So again, we put more in there probably than we were allowed to, but we figure if she threw it out, she threw it out. We reiterated again what our closing arguments were.
Okay, well, so that's the segue into the next topic, which is post-hearing submissions. So what happened in your case is that the AE probably asked, and this is either side can ask for 5 working days, business days, to submit additional documents. That is up to the hearing officer. It's not a right, but you can certainly ask, and it's called holding the record open. So you then have 5 business days, and as in your case, Brett and Robin, you had the opportunity to respond to those documents that were submitted afterwards. All right, now we get down to the decision. Decisions are not made at the hearing. They go back and they can take weeks and sometimes months. The hearing officers or the hearing decision has up to 90 days actually from the date of the hearing for a decision to be rendered. That's why it is so important, if we're talking about a service that you already have, to get that appeal in within that 10 days, or you can argue if it's within 15 days, so that the services will continue, because these hearings, not only do you have some time before you actually have the hearing, but up to 90 days afterwards. If the decision isn't issued before the end of the period for which a variance is requested, this gets a little tricky. And I've seen this a lot in cases involving nursing cases under regular medical assistance, where the approvals are for like 6 months. The rule there, and I'm assuming that may well be the case for variances, is that even though you don't have, even if the variance period expires before you get the hearing decision, you need to actually to ensure that you have the right to continue the services that you've already gotten, you need to actually make a new variance request for the new period. The AE will then deny, and you file yet another appeal. I know this is crazy, but this is what is necessary to ensure that you continue to receive the services while you're waiting for the hearing decision. Let's see what else. If this is a new service or a service which has been stopped because you didn't get the appeal in time, after the 90 days, you can request that the AE start the service that was under appeal. This is something called interim assistance, and there is a regulation about that. Now, now finally, as to the hearing decision, what does this thing look like? It's a little confusing because I'm going to show you one that is redacted. And here we go. And here we go. And this is actually the one that I showed you where we talked about having evidence considered where the county had said, well, we denied the service because we didn't get the documentation and it wasn't in the ISP. And the hearing officer said, no, that's not the rule. The rule is you can submit other information as long as it pertains to the time and issue. And the issue is whether the person was eligible at the time, not whether the documentation was provided. This is actually what the hearing decision looks like. This is the front page, the cover page. You look on this, and what you see is hereby order and decree the decision of the administrative law judge is affirmed. Affirmed. Oh, that means I won. Nope, that doesn't. This front page doesn't tell you anything about whether it was whether you won or lost. So you have to get beyond that. So next page, here we go. This is a corrected order. This is a case where the ALJ kind of screwed up their order, and I had to contact the ALJ and say, wait a minute, what you did isn't consistent with what your opinion. And so they had to do a corrected order. Here it is here. So this is where you actually see whether you won or lost. All right. And it's in this part here. And so you can see it says denied in part, sustained in part. So in this case, because we were dealing with different hours at different times, some enhanced and some and some 2-on-1, it was a little confusing. So this kind of split decision. But the point is, if it says denied, you've lost. If it says sustained, that means you've won. That's what this order here does. And moving on, then we have the adjudication. And this talks about who was present, who was at the time and the date. One thing I'm going to point out here, which is interesting, doesn't always happen, but just so you know, you'll see here that there are two different hearing officers or administrative law judges, as they're calling them here. There was one hearing officer or administrative law judge who actually held the hearing, but there was a different judge who decided the case. In this case, they say adjudicated, decided the case. So that can happen. In this case, it happened because I actually took the previous hearing decision to court and won, and they sent it back. And so they had a different judge do the final decision. But anyway, so that's that. And then there's all these things. These are all the exhibits. And remember, the judge, hearing officer, can only consider those documents that were admitted into evidence as exhibits. So here's the list. And again, you see C1, C2, those are for the AE. And then these were R's, A1. And then you have findings of fact. Those are important based on the evidence presented This is what the hearing officer determines are the facts. And it goes on and on. Discussion, then what are the regulations? Big talk about regulations. And then analysis and conclusion. This is where they said about the issue was whether the information we presented at the hearing showed that this individual, in fact, met the requirements for enhanced and 2-to-1, etc. And then there was a decision. So that's what this thing actually looks like. I know it's confusing, but it is a very formalized template that they use. Okay. And then second to last thing is appeals. If you lose, you do have the right to appeal this decision. And as it'll actually show it here on this front page, you have the right to file something called a reconsideration. And there's a form which is usually attached to the hearing decision, which you fill out. It's pretty simple. Don't need a lawyer for it. But you only have 15 days from the date, this date here. This is the date you go by. The final administrative action order date. Okay, that's the date. 15 days from there is the date you have to get your reconsideration in. It goes to the Director of Bureau of Hearings and Appeals, but they then send it to certain staff for the Secretary of the Department of Human Services. Secretary, that's Val Arkush. She has some staff who do these reconsiderations, and they will look at it. What's important to know is that no new evidence can be presented at the for reconsideration. You are limited to the exhibits that are already here, and furthermore, the reconsideration will not overturn these findings of fact unless you can show that there was lack of what's called substantial evidence, lack of evidence presented to support the finding of fact. So that's really difficult. There is also an appeal to court that can be made. This is to a special state appeal court called Commonwealth Court. I can tell you from experience, you have 30 days for that, but I can tell you from experience, this is where you really do need a lawyer. For all these other, the appeals, the reconsideration, you don't need a lawyer. It's great to have legal advice, but it's not essential. But you get to Commonwealth Court. I mean, people do this on their own, and I can tell you that a lot of them get kicked out by the court clerk just kicks them out because they do this rule to show cause that Brett had mentioned, and they get kicked out for failing to comply with some very complex, arcane rules of appellate procedure. So I would advise against trying to do this on your own. Okay, so then I'm going to give last word to the Buckwaters, and this is entitled Lessons Learned.
Oh my. I think the biggest lesson I learned is that nobody's an expert in this. You're doing this, you've never done this before, and there's no one really to give you to be there in your shoes with you. And I found the AE, it's an interesting issue in that the AE is sometimes your friend when you're out there trying to get services. And when you go into the courtroom, they are on the other side of the table. So you sometimes, one of the things that Robin and I wanted to make sure was that we didn't make this personal with them, because you might need them again in the future for services. And that's something I learned. The other thing I learned is the court is not very technology friendly. Although they record all of this, they record it on video and on, excuse me, they record this in video and audio. They don't really are not up to speed with a lot of things like email and video and technology. And I see we're coming to the end here, David. So I think that's my lessons learned.
Okay. Now let me just say that we're sorry we didn't have time to answer questions live, but I'm not dodging your questions. I've done this before with Vision. They are going to send me your questions. I will do my utmost to answer those questions for you. And if there those some that you want to ask the Buckwalters, that will be up to them. They will decide, whether and what questions they can answer. But I will be happy to answer questions to the extent I'm able to your questions. So please don't feel like we're dodging any questions. We will do our best. It just simply, it has taken an hour and a half to go through this material. And I think we're all kind of exhausted. It's very complex stuff. So we could do another hour just of answering questions, although physically, I don't think I could make it. So we will do that. Just give us some time to review the questions, and then we will get back to you. We will rely on Vision to transmit those questions back to you guys who have asked you questions. As I said, I am going to be sending my outline and the documents I've shown to Vision, and they will forward them to those of you who have participated in this presentation. And then I don't know if there's anything else, Francine, that you want to say now? Wrap it up?
No, I mean, we really appreciate your time, David, and certainly the Buckwalter family. And we know it's a vulnerable position, so we really, really appreciate your joining us. If David and Buckwalters could just check your chats, and if you have any questions that got sent to you, please forward them to me. And yeah, we will see what questions we have, and everyone registered. So we have the email addresses of those who ask questions, and we'll get back to you if we're able to get the questions answered. And this will be posted, this video. It will take a little while. It has to be edited and captions have to be added. So it will take time, but it will eventually be posted on Vision for Equality's YouTube page and linked to our visionforequality.org website. So if you want to look out for it, that's great. And have a great afternoon and evening, and I hope it cools off for everybody. Thanks, everyone. Bye-bye.
Thank you all.